Hello and welcome to Lawyer. Today with us we have Advocate Nikhil Kumar, Associate at Maestro Legal, who shall share his brief on the topic abuse of dominant position. Welcome, sir.
Thank you, Risha. So,
Thank you so much, sir. This is the topic which actually needs your brief attention at this moment. Could you just brief us about the same?
basically, with the advent of various new market like digital market and various e-commerce platforms, it is very important to discuss the competition concern in the market, right? So the abuse of dominant position is one of the issues which is very important for any e-commerce platform or any kind of market to be discussed or to be pointed out so that the competition concern in the market can be rectified, right? So now I would like to start with the introduction of abuse of dominant position. And before that, I would like to introduce the concept, the competition in the market itself, that what India have competition regime. Uh, so uh, the the this topic is the topic of abuse of dominant position is one of the topic under the competition regime in India. So first of all, I would like to introduce that what is the competition law, like what are the objective of competition law. There are four objectives of competition law, that is to prevent practices having adverse effect on competition. Like in Indian market or in any kind of market where competition is one of the thing due to which consumers get a better price or better condition on product or services, right? So competition, the CCI, the adjudicating body or the enforcement body of competition in the market, that is CCI, is bound to prevent practices having adverse effect on competition, which directly or indirectly enable the consumers to get better offer on services and goods. The second objective of the competition law is to promote and sustain competition in market. So the another objective of CCI under competition law is to promote and sustain competition in the market. If competition will be better, then ultimately the consumer will get better price in the market. Now, the third point is to protect the interest of consumers. So, in India, there is another legislation called Consumer Protection Act. But with that also, Competition Commission serves interest of consumer under competition law also. जबकि हमारे इंडिया में अभी अवेलेबल है दूसरे लेजिस्लेशन जो कंज्यूमर कंसर्न्स को एड्रेस कर रहे हैं, but still competition law covers the provisions which protect the interest of consumers, right? So and the last objective of the competition law is to ensure freedom of trade carried on by other participants in market. So basically, all these four objective of competition law is to enhance the pro-competitive actions of players and to address or prohibit the anti-competitive effects of the action of competitors. So, with this brief introduction of objective of competition law, I would like to define that what competition law covers, how competition law work to address all these objectives. So, there are three topics which is covered under Competition Law 2002, and the first one is prohibition of anti-competitive agreement, prohibition of abuse of dominant position, and regulation of combination, right? So coming to this, सबसे पहले I would like to note that I would like to highlight that the term prohibition in two of the segment, that is prohibition of anti-competitive agreement and prohibition of abuse of dominant position. But you can see the regulation of combination. What is difference between prohibition and regulation is, prohibition means it is completely banned, it is completely prohibited, that anti-competitive agreement cannot be possible in Indian market, or abuse of dominant position cannot be possible in Indian market. But combinations are regulated in Indian market by CCI.
Correct.
So the total scheme, the whole scheme of this competition law 2002 is to prohibit anti-competitive agreements, to prohibit abuse of dominant position, and regulation of combination. Now our topic is about the abuse of dominant position. So let's discuss the abuse of dominant position.
Right.
So, under this abuse of dominant position, I would like to discuss 4 points very briefly. And the first point, that is understanding the concept of abuse of dominant position. So, the scheme of abuse of dominant position, we can see that the term itself called prohibition of abuse of dominant position, which means that under Section 4 of Competition Act, the abuse of dominant position is prohibited, which means that dominance to attain dominant position is not prohibited, the
Correct.
abuse is prohibited. So to discuss the concept of abuse of dominant position, we have to understand the scheme of Section 4 of the act. So scheme of the Section 4 of the act suggests that the dominant position is not prohibited to because it can be, the dominant position can be attained through hard work of enterprise, or can be attained through better management of company, right? So therefore the dominant position is not prohibited, but abuse of such dominant position is prohibited under the scheme of Section 4 of the act. Now let's understand the total scheme of dominant position, how abuse is prohibited, and under what cases the action of enterprise is prohibited. So इसके लिए सबसे पहले we have to understand 3 points, that to get or to know that what enterprise is under dominant, or in what enterprise is enjoying dominant position, we have to understand the market first, that कि किस market में such enterprise is dominant. So therefore the first and foremost pointer which can be discussed, or which have to ascertain is defining the relevant market. So how we define relevant market is very important, because जब CCI cases deal करती है तो सबसे पहले वो देखती है that informant ने क्या relevant market define किया है, and the other party, that is opposite party, what they have defined the relevant market, right? After getting the both after getting and analyzing the both the relevant market defined by informant as well as the opposite party, then CCI analyzed that what should be the exact relevant market in the concern, in the matter in concern, right? Like अगर मैं example लूँ for of Google, like so Google, we can say in layman language, we can say ये बहुत आसानी से दिख रहा है कि Google is a dominant player, like in a search engine market. If we define that Google is operating in market of search engine, then it is very visible that Google is in dominant position. But
Right.
is it? We have to find out that क्या गूगल अभी डोमिनेंट पोजीशन एंजॉय कर रहा है, तो उसके लिए देयर आर फैक्टर्स डिफाइंड अंडर सेक्शन 4 ऑफ द सॉरी सेक्शन 19 सब क्लॉज 4 ऑफ द एक्ट. सो सबसे पहले वी हैव, अगर हमें अब्यूज ऑफ डोमिनेंट पोजीशन को बाइफरकेट करना, अगर हमें एनालाइज करना है कि क्या डोमिनेंट पोजीशन में है कोई एंटरप्राइज, तो वी हैव टू अंडरस्टैंड थ्री थिंग्स. First of all, the relevant market. Then we have to define that under that relevant market, the particular enterprise is in dominant position. Then we can, then the section 4 of the act, that is prohibition of abuse of dominant position, is triggered. तो सबसे पहले to trigger the section 4 of the act, to trigger the scheme of the section 4 of the act, we have to understand the concept of relevant market and dominant position. So let's discuss what is relevant market. So relevant market is also defined under section 2 of the act. So relevant market is a combination of relevant product market and relevant geographic market. So what is relevant product market now? So relevant product market is something like the particular enterprise, like Google. Let's take the example of Google only. That Google is operating in which kind of market, which product. अगर वो सर्च इंजन के मार्केट में कर रहा है ऑपरेट, तो वी हैव टू अंडरस्टैंड द प्रोडक्ट इन द क्वेश्चन इज मार्केट ऑफ सर्च इंजन. अब हमें देखना होगा कि क्या सर्च इंजन का मार्केट कितना बड़ा है. हाउ वी हैव टू डिफाइन इज द प्रोडक्ट सब्स्टिट्यूटेबिलिटी टेस्ट. सो प्रोडक्ट सब्स्टिट्यूटेबिलिटी मींस that on the basis of from the point of view of consumer, from the point of view of consumer we have to take, or we have to understand the point of view of consumer, that what product can be substituted. अगर सर्च इंजन का प्राइस बढ़ा है, अगर गूगल चार्ज कर रही है आज सर्च इंजन को यूज करने के लिए ₹10, बट अगर कल को वो 20 करेगी, तो कंज्यूमर्स किस किस और सर्च इंजन प्रोवाइडर्स को शिफ्ट कर सकते हैं. तो अगर देयर इज अ पावर ऑफ सब्स्टिट्यूटेबिलिटी विद कंज्यूमर, then every each enterprise which is providing the service of search engine is is competitor of Google. So the first and foremost test for the relevant, defining the relevant market, is gogging the product substitutability from the consumer point of view, right? And the another factor, that is determining of geographical market. So how we define geographical market? So geographical market means that at what extent, at what geographic extent the services is provided. And also like Google, अगर मैं बात करूं इंडिया के मार्केट में, तो गूगल पूरे इंडिया में सर्विस प्रोवाइड कर रहा है. सो द इफ वी डिफाइन द मार्केट ऑफ गूगल, so the market will be Google is operating in market of search engine whole India, right? So the relevant market is the relevant market of Google is, so the relevant market of Google is the search engine market in whole India. Now we have to consider, we have defined the relevant market. Now we have to define the dominant position of the player. So we have to define dominant position with various factors given under 19 subclause 4 of the Act. So in section 19 subclause 4, there are various factors like market size, market share, that how much share of the whole market Google is operating in. Like Google holds, I guess, above more than 50% market, and the consumer dependency, the size of the competitors, and there are various factors like it is till M points. So it can be 13 to 14 points, which is given under section 19 subclause 4 to define the dominant position. There are factors given that if player is holding more than 50% market share, it can be said that the player is enjoying dominant position. But it is not ascertained that if any player is having 50% of market share, it is not sure that that particular entity is enjoying dominant position. We have to take other criteria, we have to consider other factors also. Okay, so with this we have completed two tests of before triggering the abuse of dominant position. Now let's move to the point of abuse of dominant position. So abuse of dominant position, we have defined the relevant market, then we have defined the dominant position, then we can only trigger the section 4, the scheme of the section 4, that is abuse of dominant position, which is prohibited under section 4 of the Act. अब अब्यूज का जो केस है यहाँ पे क्या है, जब आपने डिफाइन कर दिया दैट गूगल इज इन ऑपरेटिंग इन दिस मार्केट एंड आल्सो द गूगल इज एंजॉयिंग डोमिनेंट पोजीशन इन दैट पर्टिकुलर मार्केट, देन it is duty of Google to avoid certain things which is defined, or which is the scheme of abuse. So the first and foremost thing is to impose conditions on use or on price. Okay, like जियो ने जब जब जियो मार्केट में आया, so they imposed, like they provided the services on minimum charges. और उस टाइम पे फिर एक केस आया प्रीडेटरी प्राइसिंग को लेकर, एक केस आया. सो व्हाट द कॉन्सेप्ट ऑफ प्रीडेटरी प्राइसिंग इज imposing the imposing discriminatory pricing or any other conditions which will lead to ousting the other competitor from market, or any conditions or imposition of any kind of discriminatory or unfair pricing in the market, including predatory pricing. What predatory pricing is? Predatory pricing means the setting the cost price, setting the selling price of the product or services less than the cost price of the product. तो जियो ने उस टाइम पे क्या किया? जियो ने उस टाइम पे ये किया कि उन्होंने जो सर्विसेज प्रोवाइड किए वो इतने मिनिमल थे कि जो जितने अदर कॉम्पिटिटर्स थे वो compete नहीं कर पाए और वो मार्केट से बाहर चले गए. बट जियो ने अपने आर्ग्यूमेंट्स दिए और जियो का जो भी इशू है अभी सीसीआई में है. Now moving to another action which lead to abuse of dominant position is bundling and time. Bundling and time means when you suggest that you have to you will get phone until and unless you buy the charger. So this is bundling, that you want to sell a product by bundling the other product with it. So this is also by you are using the your dominant position in the market to sell other product with it, right? So this is the second scheme of abuse of dominant position, with the action which can be construed as abuse. The third thing is leveraging your dominant position of one market to another market, राइट. जैसे अगर मैं बात करूं अभी बाइजूस का, अगर मैं वी कैन टेक एग्जांपल ऑफ बाइजूस, दैट बाइजूस इज डूइंग वेरी ग्रेट. अभी मार्केट में बाइजूस इज ग्रोइंग लाइक एनीथिंग. अभी मार्केट में जो अगर मैं डिफाइन करूं बाइजूस का, सो बाइजूस कैन बी कंस्ट्रूड इन द मार्केट ऑफ डिजिटल ई लर्निंग थिंग. बट जैसे उन्होंने आकाश को खरीदा, जैसे दे 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 बाय दी आकाश, जो कि फिजिकल प्लेटफॉर्म में है, जो कि ट्रेडिशनल प्लेटफॉर्म पे है, जो कि एक कन्वेंशनल सेट ऑफ कोचिंग सेंटर है, उसको जैसे उन्होंने खरीदा, सो वी कैन से दैट वो एक मार्केट का जो डोमिनेंट पोजीशन है उसका वो दूसरे में लेवरेज कर रहा है. बट yeah, until and unless it is proved that the relevant market and the dominant position of Byju's, we cannot say that Byju's is abusing. But for an example, I am saying that this is the definition of leveraging the dominant position of one market to another market. Now the last thing of abuse is denying the market access. Like JCB has denied market access of heavy machinery for other competitors initially. So उसका एक competition concern आया था CCI के अंदर. So all these the scheme of section 4 is only triggered. हमने अभी ये देखा कि वो तभी वो ट्रिगर करेगा द स्कीम ऑफ सेक्शन 4 until and unless you prove the relevant market. Then you have to prove the dominant position of the entity in that particular relevant market, and then only you get to satisfy the section 4, the elements of section 4 of the act, to construe that the particular enterprise is abusing its dominant position. So I think I have discussed all the important thing related to abuse of dominant position. And since abuse of dominant position is very vast topic to discuss, but we can consider that I tried to cover all those points in very briefly. So that's all for from me, and many thanks for your time.
Thank you so much, sir. Putting an end to such an amazing session, I would like to thank Advocate Nikhil to make his present with us, and thank you so much for your insightful on the set topic.
Thank
Thank
you, Udrisa, for providing your platform to address things, and I'm really grateful for it.
thank you so much, sir. Thank you.
Thank you.